Okay, we're on record today for a preliminary hearing and a request for removal. And the names of our participants, please.
Lee Heiss, lawyer guardian ad litem.
Ms. Saja Thomas, counsel for the department.
Deja Miles with the department.
Michael Brooks, I'm the attorney for Gerald Quincy Gerald Quincy Turns, excuse me. The legal father of both of these boys. Sir?
I'm Gerald Turnus, father of the kids.
Michael McFarland representing mother, please introduce yourself.
Angela Rosas, I'm the mother.
Thank you. Anything in opening, Ms. Thomas?
Your Honor, I don't know if you want to adjust the sidebar at all.
Oh, right, yes.
I will leave it to your attorney's update.
Well, my understanding is what we talked about, the sidebar is simply having very brief testimony from each of the parents indicating their position on abuse and neglect of these children. What they say is up to them. I'm not going to presuppose it. And then you're going to make a decision whether you have enough information to for removal.
Yes, that's also because I understand that there is a request for trial, right? So.
From me, Your Honor, yes, a bench trial.
I think my client's going to admit enough that you may be willing to take jurisdiction.
In addition, my client has a couple individuals, an aunt and a mother. The removal is determined by this court. In addition, my client would like the petition read to her today. And I have gone over her rights in a bench trial, so she's requested.
I have Friday, July 26th. Oh, Ms. Heiss is gone then.
August 20th.
Back up. August 30th.
I'm due August 20th for, I'm pregnant at the moment.
So you don't think you're going to be able to participate by the 30th?
I don't know. It just depends on if we get out of the hospital and she's doing okay and if I'm doing okay.
Do you think, Ms. McFarland, you want a half day or a full day?
Full day. Based upon the witnesses and the testimony.
I should also point out my client is questioning the paternity of both of the children who are born and the child that this lady's presently carrying.
And Judge, I was just going to offer, it looks like we had a jury trial scheduled for July 22nd and 23rd, and those parents have both entered pleas, and I don't know if those days are still available for the court.
Yeah.
Okay.
You can have a backup to jury trial on August 19th. Oh, yeah, you can have that actually. Okay.
August 19th.
That's the date before, Your Honor. I'm not sure that my client might not be in the hospital or the frame of mind the day before the delivery.
But I can do the 30th. I can try to be here on the 30th.
I will advise the court, I will ask my client to contact me after the verdict to let me know status as soon as possible, Your Honor.
I can give you Monday the 5th if that helps.
Of that September?
August 5th.
Okay, that's fine.
Okay.
You're a backup on that too.
Which I may or may not need, depending on what the court decides here.
Very good, yes.
9 o'clock.
We'll call it a pre-trial for your client because I'm assuming we're gonna order DNA testing. And then we'll treat it as a pre-trial or a trial, whatever we're ready for. Judge. All right, any other comments about the sidebar before we get started?
I think I've told you everything I know.
Mr. McDonald?
No, thank you.
I will add, I believe, and I don't, Mr. Cronin, I'm so sorry if you said this, but I believe that Ms. Rosas has reported possible Navajo
Yes, I was just gonna say that. if you didn't.
affiliation, and we do have tribal notices sent to the Cherokee Nations, but not Navajo, so we know that that needs to get done.
Did I hear you say he's tested as Navajo?
No, she's reported possible Navajo
Oh. Okay.
membership.
It's at 9 o'clock on the, fifth, Your Honor.
August 5th, yes. Deputy Ames, would you swear in both parents, please? Okay. All right. Have you both received a copy of the petition, Mr. Turns?
Yes, ma'am.
Ms. Rosas? Yes, ma'am. Okay. Have you disclosed all information about Native American heritage to the caseworker?
Yes, ma'am, sorry.
Okay. Mr. Turns? Is that a yes? Thank you. Okay. You have the right to an attorney, which is why we've had the Public Defender's Office provide you attorneys today. If you want to retain your own attorney, you're welcome to do so. That person just would have to file a substitution and get all of the documentation from your current attorney. Let's see. Today's hearing is about whether or not I will authorize the petition and whether or not I will remove the children from your care. So I have to make those two decisions as a result of today's hearing. It's governed by the procedures in MCR 3.965. Folks are well versed in this type of proceeding. You should now hearsay is admissible during a court hearing like this. I will be reading the petition to you, so I'll get to that in just a few minutes. You have a right to trial by judge or jury. Right now, we've scheduled you for a bench trial, which means your trial would be in front of me. If you change your mind and you want a jury trial, you have 14 days to put that in writing and have it filed. Yes, ma'am. You have the right to seek placement at this hearing, which I think you already know. You intend to do that, as I understand it. You have the right to admit or deny the allegations and make a statement of explanation. Are there any other cases concerning these children, like guardianship, child support, or anything like that, Mr. Turns?
Not yet. I actually called a lawyer last week about trying to go to friend court. I'm still waiting to hear back from him, but I can't do until this is over.
Ms. Rosas? Okay, well, I think that's it for our preliminaries. We'll get the DNA testing going for the children as well. And I know that there is a search underway to see if any other state has already determined that you are the legal father of the children. And the department is seeking those
If it's of
records.
any assistance, my clients told me here that the boys were born in California and Texas respectively. I don't know which was which, but those are the states.
Thank you. All right, well, I will go over the petition with you now then. So the first page is part of a form JCO4B, and it just simply identifies both parents and children, including their names, dates of birth, place of birth, race and sex, and I'm going to leave that off the record. It's confidential information, and it's typically something we don't disclose anyway. Page 2 begins with 3A. There are no pending or resolved other cases, which I went over with both parents. Number 4, there's an allegation that both children come within the provisions of MCL 712A.2B1 through 6, specifically alleging that the parent or other person legally responsible for the care and maintenance of the children, when able to do so, neglected or refused to provide proper care or necessary support, education, medical, surgical, or other care necessary for the children's health or morals, or he or she has subjected the children to a substantial risk of harm to his or her mental well-being, or he or she has abandoned the children without proper custody or guardianship. The second allegation of the statute is that home or environment by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent, guardian, non-parent, adult, or other custodian is an unfit place for the children to live. Subsection 5 indicates the reasons why it's contrary to the welfare of the children for the children to remain in the home with the parents. Following are, well, I'm going to try to avoid saying their names on PNN are currently admitted at U of M Mott Children's Hospital due to failure to thrive because they are underweight. And also has a healing left tibial fracture, no previous medical attention for the injury. Neither child was found to have any physiologic reason for failure to thrive. Findings are consistent with physical and medical neglect. There's also a reason to believe the parents are a flight risk based on previous history of evading CPS. Paragraph 6. Reasonable efforts made to prevent the removal of the children include early on CPS investigation, safety planning, child medical evaluation at Hickman ER, U of M child protection team medical evaluation, family team meeting, offered Catherine Cobb and DV resources, provided gas cards, diapers, wipes, and baby supplies, and bridges assistance. The next page indicates specific allegations as attached for the essential facts that constitute the offense against the children of the juvenile code, and the request for relief, which is specifically to authorize the petition, take jurisdiction over the children, and issue an order removing the children from the home. Signed, of course, by Deja Miles from the department and Ms. Thomas, the attorney for the department. The addendum is next. Addendum to petition for removal and jurisdiction as to respondent parents. Jurisdiction and venue. 1. Angel Marie Rosas is the biological mother of the subject minors. 2. Is it Cheryl or Jarrell?
Jarrell.
Jarrell Quincy Turns is the legal father of the subject minors. Both parents indicate that Mr. Turns is the children's biological father. Each child's birth certificate has been obtained. I don't know if that's true.
I think that's accurate.
Yeah.
I think I missed has not.
Okay. CPS is in the process of requesting each state-specific AOP or equivalent. 3. The subject minors may be members of or eligible for membership in an American Indian tribe or band. Angel Marie Rosas was asked on 5/9/2024 and indicated that she and the subject minors have Native American heritage. Jarrell Quincy Turns was asked on 5/9/24 and indicated that he and the subject minors have Native American heritage. Subparagraph A, on 5/9/2024, a genogram was completed with Angel Rosas and Jarrell Turns. Based on the information provided by Angel Rosas and Jarrell Turns, a DHS 5598 was completed and mailed to the Bureau of Indian Affairs. Please see the attached copy of relevant documents. Subparagraph B, on 6/3/2024, notice of the CPS investigation was sent to the Bureau of Indian Affairs. 4. The subject minors are residents of Lenawee County, Michigan. The subject minors are currently located at University of Michigan Mott's Children's Hospital. 5. The incident of alleged abuse and neglect occurred in Lenawee County, Michigan. The next section is titled Factual Allegations. Neglect: physical, educational, medical, emotional, substantial risk of harm to mental well-being and unfit home environment, neglect, and cruelty. 6. Complaint details. On 5/4/2024, the department received a complaint alleging physical injury of N. Turns. The complaint alleged there were purple bruises on N's forehead and what appeared to be a handprint mark on his cheek. 7. On 5/4/2024 at 9:15 p.m., the on-call worker Jill Tipton made face-to-face contact with the family. N was observed to have bruising on his forehead. Jill Tipton took photos of the bruises on N's forehead. Family reports that the bruising was from N. Turns 1 and P. Turns 2 fighting with each other. A safety plan was developed. 8. On 5/9/2024, the assigned investigator Deja Miles made contact with the family. A different explanation for the bruising was provided. Parents indicated that when the boys wear socks on the hardwood floors, it makes it slippery, causing the children to fall. And that is how the bruising occurred. 9. On 5/10/24, Angel's mother, Crystal Rosas, texted the worker and informed the investigator she currently has the children. Crystal Rosas indicated she had an active power of attorney and agreed to take the children for a medical exam. The pediatrician denied seeing the children due to no active insurance. Assistance was provided with bridges and insurance was activated. 10. On 5/17/24, Angel took N and P to Hickman Emergency Room for medical evaluation. Both were seen by Dr. Watts. Dr. Watts called the investigator and indicated that he had no concerns for abuse. 11. On 5/24/24, CPS dropped off 2 packs of diapers and 3 packs of wipes for the family. Angel did not indicate any concerns to the worker at that time. On 5/28/24, Angel indicated that after she was released from the hospital on 5/23/24, she observed new injuries on the children from Jarrell, but made no indication to worker on 5/24/24 when at home. 12. On 5/28/24, the worker met face-to-face with the family. P and N were both viewed to have new bruises. A new medical was requested. 13. Angel reported domestic violence concerns between her and Jarrell. Angel reported being afraid of Jarrell and that they had separated. CPS provided Angel the contact information for the Catherine Cobb shelter, as well as the information for the DV awareness hotline. On 5/28/24, Jarrell Turns and CPS met face-to-face. Jarrell stated that Angel has been abusing both children since they were 3 months old. Angel will put her hand over their mouths and smokes cannabis around the children. He felt it would be best if the children were placed in foster care, as he believes neither he nor Angel should have the children at this time. 15, on 5/30/24, the department received a new complaint alleging that Angel, who is 6 months pregnant, is drug seeking at Hickman Hospital ER 3 to 4 times a week. Domestic violence concerns and new bruising on the children, including a bite mark on P. 16, 5/30/24, the worker made face-to-face contact with the children at the home of their maternal grandmother, Crystal Rosas, and maternal aunt, Roxanne Rosas. Subparagraph A. Paul had a healing bite mark on his left shoulder. The mark was large and covered approximately his entire shoulder. He also had a mark on his shin that looked like it could be a cigarette burn or a scratch. He also had a scratch on his upper abdomen that his great aunt Roxanne indicated had been bruised the day before. B. N was viewed to have a bruise on his right foot, a scratch on his finger. The worker took photos of all the marks and bruises found on each child. C. This time, Angel was in the hospital in the process of being discharged. Angel had not taken the children for a new medical since CPS requested 2 days prior. CPS contacted Angel and the family and requested the children to U of M for a medical exam by a child protection team for a second opinion. And DHHS provided gas cards for transportation. 17, the morning of 5/31/24, Angel had reported that they had not taken the children to Mott's Children's Hospital that night due to her aunt not liking to drive in the dark. However, she reported that they were taking them that morning. 18, on 5/31/24, Erin Loomer, a social worker at the University of Michigan Mott's Children's Hospital, called to inform the worker that both children were being admitted for failure to thrive. Erin indicated they were too underweight to even put them on the percentile chart. She also reported that they each had their skeletal survey exams completed. She reported that P's survey came back with no concerns. She reported that N's skeletal survey came back and showed healing left tibia fracture of unknown origin. It is unknown when this injury occurred or how it was caused. 19. 5/31/24, a family team meeting was held. The following information was obtained. A. CPS learned N has seizures. He has never had an established pediatrician or neurologist. B. Jarrell admitted to knowing N had rolled his ankle, but instead of taking him for medical treatment, he chose to place him in a pack and play for approximately 2 to 3 days until he no longer cried from walking on it. Jarrell reported he did not take N for medical attention because he did not have any bruising or swelling. C. Jarrell admitted they move states anytime CPS opens a case. The parents have a CPS case history in Texas, Kentucky, California, and Ohio. D. Jarrell and Angel each made disclosures that the other was abusing the children in various forms. E. Failure to thrive was discussed with the parents. They indicated they feed the children, they provide fruits, vegetables, and meat when they need it. 20. The safety plan was developed during the FTM, stating the parents would not use physical discipline of the children. On 6/2/24, CPS was notified by U of M that Angel spanked P and was informed by staff that physical discipline was not allowed in the facility. 21. Following a CPS investigation in November of 23, the family was referred to early on services in Monroe County. Both children qualified for services, but the parents did not follow through. N. Concerns included social, emotional development, and having a flat head. B. P qualified for communication delay. Paragraph 22, CPS history. There are prior substantiated CPS cases in which Angel Rosas and Jarrell Turns were determined to be perpetrators of the following investigations. A. 3/9/21, Trigg County, Kentucky. There was investigation for physical injury against Amber Turns by Angel Rosas and Jarrell Turns. There were several bite marks on Amber Turns. The investigation was confirmed for abuse. However, it was closed due to A. Turns moving back to Michigan to live with her mother. Angel Rosas and Jarrell had no longer had access to Amber Turns. B. There is believed to be more CPS history in other states, including California, Texas, and Ohio. CPS has not yet received the records from the corresponding states. 23. Currently, the maternal grandmother has a power of attorney for both children. However, she is unable physically to care for the children due to her health. There are no other appropriate relatives to place the children with. Statutory citations. 24. Statutory grounds for adjudication. Based on the above stated allegations, jurisdiction is proper under the following subsections of MCL 712A.2b. Children are under the age of 18 and A. 1. The children's parents, when able to do so, neglects or refuses to provide proper care or necessary support, education, medical, surgical, or other care necessary for the children's health and morals, are subject to a substantial risk of harm to their mental well-being, or abandoned by their parents, or who is without proper care proper custody or guardianship. And B, 2, the children's home or environment, which Rel turns and Angel Rosas by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent is an unfit place for the juveniles to live in. Paragraph 25. Statutory grounds for removal. Based on the above stated allegations and pursuant to MCL 7128.13A9, removal of the children from the respondent parent's care and custody is necessary, and placement of the children into foster care is necessary, as all of the following are true. A, custody of the child with the parent presents a substantial risk of harm to the child's life, physical health, or mental well-being. B, no provision of service or other arrangement except removal of the child is reasonably available to adequately safeguard the child from the risk as described in subdivision A. C, continuing the child's residence in the home is contrary to the child's welfare. D, consistent with the circumstances, reasonable efforts were made to prevent or eliminate the need for removal of the child. E, conditions of child custody away from the parent are adequate to safeguard the child's health and welfare. Relief requested. 1, authorize this petition for removal and jurisdiction as to respondent parents, Jarrell Turns and Angel Rosas. Issue an order removing the children from the care and custody of respondent parents, Jarrell Turns and Angel Rosas, placing the children in the care and custody of the department to be placed in foster care home. 3, take jurisdiction over the child pursuant to MCL 7128.2B1 and 2. And 4, set this matter for an adjudication trial. Respectfully submitted June 6, 2024, by Sergeant Thomas and Deja Miles. There are a number of attachments. The first are medical documents from the University of Michigan. There is a set of documents supporting the department's Native American Heritage Search, including certified mail receipts, indicating that the inquiries were sent June 4th, 2024, 3 inquiries, 1 to the United Kiowa Band of Cherokee, 1 to the Cherokee Nation, and 1 to the Eastern Band of Cherokee Indians. There's also the 5598 that was referenced in the petition itself, which is the inquiry form. There's 1 for each child. There are also some color photographs. They have 1, 2, 3, 4, 5, 6, 7 of them. Counselors, would you confirm that you have the petition and all of the attachments?
Yes.
Mike Brooks may have taken my color photographs, so I can get a copy.
No, I didn't.
My client does have a copy of everything, and I have to use them.
Thank you. Very well. All
Your Honor,
right.
I do have the petition and I have reviewed the attachments and I'm assured that the attachments will be forwarded to me. I didn't get it from the clerk.
Okay. We can take that up with our clerk's office. Thank you for letting me know. All right. As it relates to the request to authorize the petition and for removal, Ms. Thomas.
Thank you, Your Honor. I'll ask Ms. Deja Miles to be sworn on these. And as the investigator, how did you, well, let me just backtrack a little bit. Your name is signed on this petition, correct?
Yes.
Okay. And the allegations that are contained in it, are those true to the best of your knowledge and belief?
Yes.
How did you gain that information that's contained in the petition?
So we went through the course of an investigation.
Ms. Miles, I'm gonna need you to speak up.
Oh, sorry. So we received the investigation. We received that on May 4th. At that time, an on-call worker went out and made contact. Seeing the bruising on Niklaus at that time, at that time, the family had reported, the parents had reported that it was from the children fighting. And that's where the bruising came from. We safety planned around that to properly supervise, and if they're fighting, to go ahead and separate them. I then went out later that week, that Thursday, which is May 9th, I believe, made contact with the parents again, brought up the allegations again, just questioning about the bruising. At that time, I was told that because they have hardwood floors, they wear socks, and they slip around and they can sometimes smack themselves on like boxes or other miscellaneous things laying around. At that point, the 2 stories I had gotten were completely different for the same injuries. So at that time, there was no indication from either parent that the other was abusing the children. and I had left. And between that, we had done some Bridges assistance because the Medicaid was not active. So once the Bridges got active again, I did ask Jarrell to relay to Angel if they could take the children for a medical. They then took the children to Hickman ER to have a medical on May 17th. At that time, Dr. Watts had called me and said he didn't have any concerns of abuse. He had only stated that Angel was not originally forthcoming as to the reason for the medical evaluation, that they were there for a cold, and then at the end of the evaluation then stated that it was for a CPS investigation. But nonetheless, he still indicated there were no concerns. The following week, Angel had went into the hospital and let me know that Jarrell had the children at that time. And she said she was in the hospital due to her pregnancy. Again, didn't relay any concerns to me. When she got released from the hospital, I dropped off those diapers and wipes to her. At that time, she didn't state any concerns. She had given me the diapers and wipes herself. Jarrell was not there or in proximity. So she had me alone to tell me anything if she wanted to. That weekend, we were going to Memorial Day weekend, so it was a longer weekend. We came back into the office on Tuesday. At that time, I had multiple missed calls and text messages from both Angel and Jarrell. Centralized Intake had emailed me as well, stating that Jarrell was trying to get in contact with me. So I spoke to Angel first. She had called me and indicated when she had gotten out of the hospital the previous week that there were new marks and bruises on both children. I had let her know that I was going to come out to the house first thing that morning to view the marks and bruises and take pictures. I did. I had seen, so N had bruising, like yellow bruising on the bridge of his nose, and had some yellow bruising on his forehead. Paul had yellow bruising on his forehead as well. At that time, Angel also indicated that Jarrell was showing up to the house, was texting her multiple times, making threats. She had indicated that there was domestic violence in the past. There were no police reports that were made, but she was afraid of Jarrell. So I had then texted her the information for Catherine Cobb, as well as the website for the domestic violence awareness hotline. So that way she could go to somewhere safe if she was afraid of Jarrell. I then spoke to Jarrell that same day at DHS, where he had indicated that Angel abuses both of the children, that she will get upset with them. She has a temper, so she will to shut that up, things of that nature. And he believed that the children were better off in foster care than to be alone with Angel. And then he also felt like he needed to get on his feet as well, so that the children could be in a good place. I told him I would conference with my supervisor. So moving forward, on May 30th, we received new allegations that mom may be drug seeking for morphine and pain pills at Hickman, approximately 3 to 4 times a week. She was constantly in and out, and that there were new marks and bruises, that there was a bite mark on Paul. So with that new investigation, Crystal and Roxanne had let me know that they currently had the children. So I went out to their home to lay eyes on the children and view the marks and the bruises. There was a scratch on the upper abdomen of Paul. There was a scratch on the leg that looked like it could have been possibly a cigarette burn, could have been a regular scratch. I took pictures of it just to be sure. And then there was also like yellow bruising around Paul's left shoulder that to me looked like a bite mark. It did not look like a child's bite mark. It looked adult size. It covered the whole loud part of Paul's shoulder. P's shoulder. And his brother is very small as well. I don't believe he could make a bite mark that large.
No, I'm going to object. This witness has not been qualified as an expert into any type of forensic determination of what are bite marks and what injuries are. She's not a, I'd like to voir dire. I think we can stipulate she's not a medical doctor and what training she's had to identify these.
Judge, I trust that you would just give due weight to her testimony based on her job title as an investigator, not trying to qualify her as an expert. I think she's simply giving her opinion as to what she observed and what may be plausible given the children's sizes.
Did you want to weigh in, Ms. Heiss?
Well, we have firsthand eyes on the child, and I think she said what she thinks it looks like, and we all know she's not an expert. She's a person who has eyes that saw it, and I think it's relevant.
Mr. Brooks?
I don't think she's qualified to testify or speculate on the cause of the bruising she saw. I think she can say she saw bruising, she can say where she saw it was on the child, but what caused it, I think it's pushing the envelope a little too far.
All right, I'm going to sustain in part, just as to the conclusions, but I can tell you that this is the testimony, it's opinion, and it's just in a way, it helps describe what the bruising looked like. So I will disregard the testimony of the conclusion and just take it as part of the description of where the bruising is. All right, you can go ahead with the next question.
I think that you're doing a really good narrating the investigatory process and how you came to put the allegations in the petition. And so, sorry, I'm just trying to scroll back to the petition here. So at this point in time, you were able to see the children with their grandmother and aunt, great aunt, and you were describing the bruise on one of the children's shoulders. Was there anything else that was concerning that day?
Yes, that day we also viewed a bruise on N's foot. And then both children were just very calm and docile. These are two toddlers that could be normal, but it is also just a little bit concerning considering they're two toddlers. Toddlers are usually laughing, playing. At one point, Paul had hurt himself and he only whined out just a very small bit and then immediately stopped, which I think is concerning because at any point I've ever made contact with these kids, they've been extremely docile. But we then, after I had left and I had called Angel, I had let her know that I had seen the children and I had asked that she take the children to U of M. We had already spoke to the aunt and the mother of Angel to discuss who would get Angel there because I had already known she does not have transportation. So we had already coordinated gas cards. We supplied gas cards so that aunt could get Angel and the boys up to U of M. She had confirmed they were going to do that night. I had reached out to the child protection team at U of M. They confirmed that they were ready for whenever Angel had gotten there with the boys. And at that point, we expected Angel and the boys to arrive there around 6 or 7 p.m. The following morning, I received an email from Martha Kerr, who works on the child protection team through U of M, and she had stated that they had not been yet. I had a couple missed voicemails and some missed calls, so I had called the aunt back, Aunt Roxanne, and then Angel as well. And I was informed that Roxanne did not like to drive at night. So they took them first thing that morning. And at the time that I spoke to them that morning, they were about approximately 4 to 5 minutes away. And I told them to just let me know, confirm once they get in there. Later that day, I had received a call from the social worker at U of M who indicated that they were being admitted to failure to thrive. And that the skeletal exams were completed on both. Paul didn't have any underlying injuries or fractures. Niklaus had the healing left fracture. They could not determine when it had happened or how it had happened. But at that time, they felt it was concerning. They were underweight to the point that they could not put them on the scale. I did follow up later that week with a different social worker, Alyssa Hewitt, who had indicated the percentiles for P. He was in the 3rd percentile for his growth. And N was less than 1 percentile for his growth and weight for his age. They had concerns. They had done multiple tests to see if there was any physiological reason as to why they were not gaining weight properly, and they did not find one. And in the report, it does notate that it aligns with physical neglect as the reason why they're not gaining weight due to lack of calorie intake. And then I had also been informed that Angel was seen physically disciplining Paul or P in the hospital room after she had been told that physical discipline is not allowed in the facility. So I learned a lot of this firsthand by laying eyes on the bruises after receiving allegations, conversations with both mom and dad and hospital staff since the children have been admitted.
Part of the petition indicates that grandma has the power of attorney over these children, correct?
Yes.
Why is that insufficient to safeguard the children to the extent that a petition was needed for removal?
So at this time, grandma is in the hospital and cannot physically care for the children. She did have the children in the past, and the children ended up being returned. And then Crystal also indicated she did not want grandma to have the children. She had indicated that there was abuse and neglect to her as a child, and that she was not comfortable with the children going with grandma. But the main reason that we know for a fact is grandma's in the hospital and can't physically care.
There's a maternal aunt that has been part of the family support system, is that correct?
Yes.
And why is that person not being explored as a potential placement?
She is not an appropriate placement as far as like CPS records and history of her own children.
Were there any other relatives that were explored?
Angel did indicate that there was a great aunt, Arlene Ramones, but we did a criminal history check and she has violent criminal history, so she would be appropriate for the children to be placed with her either.
At this time, are the children gaining weight?
Yes, they are gaining weight since they have been in the hospital.
Are there any special medical needs, like are they on feeding tubes or anything like that?
They are not on feeding tubes.
And in your opinion, I think that there's going to be this main question of, well, this case has been open for investigation for a month before a petition came in. Why did it not rise to the level of concern until recently?
There were concerns from the beginning, but neither parent was forthcoming until the week of discussion. So May 28th, that's when both parents decided to begin being forthcoming and indicating that the other is abusing the children. Prior to, I was getting different stories, and they were continuing to allege that the marks and bruises were just from like normal toddler things, such as them fighting or falling.
And do you believe that the things that you've seen and or have been reported to you pose a substantial risk of harm to the children's life, physical health, and mental well-being if they were to be returned or if they go home with their parents today?
I did.
Some of the reasonable efforts that you've testified to have included, I'm going to summarize them and then just let me know if I'm missing anything. So there's indication that there was family comedians with the parents.
Yes.
To safety plan around this. The gas cards that were provided to go to U of M.
Yes, we also provided gas cards for the Hickman ER visit as well.
And diapers and wipes were provided.
Yes.
Assistance getting the children's Medicaid activated.
Correct.
Is there anything else that I'm missing?
So there was an open investigation in Monroe last year where they had qualified for early on services. P had qualified for a speech delay and social delay, and N had a flathead and qualified for the social delay as well. They never followed, the parents never followed up with early on. And then also on the report of early on, it has a column that notates parents' concern or level of concern, and every box except for the crawling box said it was nothing was a concern to the parents.
And the available placement for the children right now is going to be a licensed foster home, is that correct?
Yes.
And are they prepared to take the children when they're ready for discharge?
Yes.
Thank you. Judge, I have no further questions of Ms. Miles at this time.
Thank you. Cross-examination, Mr. McFarland.
If I heard you correctly, doctor examined the children initially for physical injury and after it was explained to him that one of the reasons they were there was for physical injury, he determined that there was no parental abuse that occurred, correct?
Are you referring to the Hickman?
Yes.
Yes, so no concerns.
Have you asked them to take the children on the other, and then later?
Yes, I asked Mom to take, on May 28th, to take the children for another medical exam.
Okay. And you're aware that the law allows physical corporal punishment, spanking, as long as there's no injury to the child, right?
Corporal punishment is okay with spanking as long as it's appropriate.
Right, so I mean, basically, she didn't follow the hospital rules, but that's not neglect, right?
She did not follow the hospital rules. And
That's what I said, she spanked the child, but
Correct.
we're not here because there's injury to the child for that, right?
Correct.
So that's just obeying a hospital rule, we're not here because of that, right?
We did safety plan around no physical discipline at our FTM, and not even a full day later, she physically disciplined the children in the hospital.
Okay. My client indicates to me that father has told her that there's Native American heritage in his family. Are you aware of that?
Correct. They both indicated there was Native American heritage.
Okay, what Native American heritage does he have?
They both indicated Cherokee to me on May 9th.
Okay, and now you've been made aware that Navajo, my client.
Yes.
Okay, thank you. I wasn't aware of that. No further questions?
Mr. Rhodes?
You've provided a series of photographs of one of the two boys, right?
The photographs contain pictures of both children.
Oh, okay. In any event, all of these pictures give me a moment. Indicate bruising, very faintly, I might add, on the front of these boys' bodies. There are none on the back. Is that correct?
I have not viewed the back.
It's correct. These are all from the front,
Yes.
pictures of the front of the boys.
Yes.
Are you aware of there being any clinical significance to bruising on the front of a child's body as opposed to the back?
I'm not sure what your question is.
You don't understand my question? Isn't it a fact that bruising and injuries on the backs of a child or the backs of their legs are more indicative of abuse than bruises or injuries on the front of their bodies?
I did not know that.
Fair enough.
I was just looking for bruises and surrounding children.
If this judge does decide to remove these children from their parents' care, where are they going?
They are going through placement at foster home through Catholic Charities.
Not grandma or aunt.
No.
That's all.
Ms. Heiss?
Both children have a placement together.
Yes.
Are either of these children verbal where they can tell you words about where they got their bruises?
No.
Thank you, I have nothing further.
Can I ask one follow-up question?
You may.
Do either of these boys show any evidence of developmental delay?
Yes, they both have speech delays.
Thank you.
Redirect?
No, Your Honor.
Thank you for your testimony. May I return to your seat? Your next witness, Ms. Thomas?
I have no other witnesses, Your Honor.
Mr. McFarland?
One moment, Your Honor. Call my client, Your Honor.
Okay, Ms. Rosa, the witness stand.
Before we begin, I just want to advise my client of her Fifth Amendment rights, if you don't mind, Your Honor. Ma'am, there are some charges in here, physical abuse, perhaps neglect of these children that could possibly arise in criminal charges. I don't know. But if you say anything here that could be used against you, my advice is that you may not want to. Do you wish to testify today knowing that or not?
Yes, sir.
Okay. Why don't we go first with the allegations of physical abuse? Do you in any way do any physical abuse to these children?
No, sir.
You've seen the photos, right?
Yes.
Can you explain to us how you believe what the photos reflect?
I think I wasn't there for most of them. I was always in and out of the hospital. I have a bad gallbladder at the moment. And that's affected me this pregnancy at the moment. But every time I go to the hospital and come back, they had new bruises. I didn't really pay it no mind because I thought it was just them playing and being brothers and toddlers. And every time I left that, they always had new bruises. I didn't know what to think. I didn't know how to feel as a parent.
Did you bring this to anybody's attention?
Yes, my aunts, my mom, they've noticed. Every time they brought me back, we've always brought the kids downstairs so they could see them because they weren't allowed to go upstairs.
After you brought it to your aunt's attention, did she do something?
Yes, she called CPS.
Okay. And right now, what is your belief as to why the children are now in the hospital?
They're underweight, and I know that. I always fed them. I always made food for them, chorizo, eggs, potatoes, you name it. We have food in the house. I always made sure they ate.
You think they're underweight?
No, not anymore. I mean, Paul's a picky eater. He nitpicks a lot, but with him taking these protein shakes that they've been giving him, he's been drinking them nonstop.
Yeah, how about when he went to the hospital? Let me ask you that. Do you think the children were undernourished at that point in time?
Not to me, but it's up to the doctors. It's not up to me.
How is it that they got into the hospital?
They told me to take them.
And did you, as they suggested?
Yes, sir. Take it for granted, it took the next day, but they definitely went.
Now, the petition mentions that you signed a delegation of parental rights, a power of attorney to an aunt, right?
No, my mom.
To your mother. Okay, is she here in court?
No, she's at the hospital right now.
Okay. They were okay with that, correct?
Yes.
Is there some reason that you're aware of why she can't take the kids?
No, she's
Well, we
gotta
heard the
go
work.
through surgery right now.
That's what I was going to ask. You heard the worker indicate.
She needs surgery right now.
Okay. If this court were to remove the children, who would you want the kids to go to?
I would want him to go to Roxy.
And what's
I
her
really
full
do.
name?
Roxy Rosas.
This is the individual who the worker said has a prior history with protective services, correct?
But she doesn't have a case at the moment. She's fighting the grandmother right now to get her kids back. She doesn't have a CPS case open right now.
Okay. Okay. Anticipation is father's going to point the finger at you and said actually the petition said it. That father said that you choked the child with children. Is this at all true?
No,
What do you believe is this? What's the motivation there for that?
because I left him and I took off with the kids. And I haven't let him see them since.
When was this?
I want to say it was after Memorial Day, I think. I went to Catherine Cobb and we've been there for at least 3 days, and then we went to the hospital.
Catherine Cobb's a shelter for abused and battered women.
Yes, sir.
Do you feel comfortable sharing as to why you left him?
I didn't feel safe and I didn't believe the kids were safe, so we took off.
What is it that made you think that you and the children were not safe with him?
He's got a little bit of anger issues too. So when he doesn't have a cigarette or he doesn't have weed, he gets a little angry.
So when was it that you took the kids away from him and that environment and went to Catherine Cobb shelter?
I want to say it was I wanna say a Tuesday. At like 6 or 7 in the morning.
And how long were you there until the kids went to the kids weren't at the hospital at that time?
No,
When was it the kids went to the hospital?
I'm trying to remember, sorry.
That's fine, I understand this is pressure.
Sorry, I'm not good with dates.
Well, how many days after you went there?
I wanna say third day.
Okay, so when you go to the Captain Cobb shelter, you check in and somebody observed both you and the children, right?
Mhm. Yes, they did our intake.
Okay. And is it by presumption correct that somebody there kind of monitors how you and the children are doing?
Yes, sir.
That those individuals are individual here in court today?
No,
Okay. Well, anybody at the shelter tell you, hey, these kids look malnourished, underweight, that you need to take them to the hospital? Anybody tell you that?
no. They actually thought they were fine. They were playing with all the toys there. They were having fun.
Were they eating while they were there?
Yes. They provide all the food there. They make sure kids have the juices and all the things that they need, and it's there for us to grab for the kids.
Also in the petition, there's an allegation of a broken bone, correct? That was not discovered?
Yes.
Do you know the child had a broken bone?
No,
And remember, we don't use names, so.
sorry.
Yeah, I don't think you did. I'm just giving you a heads up. Go ahead.
N was playing, I guess, on a shower rod where you hang your shower curtain out.
Sure, that's a shower head.
And apparently he slipped and twisted his ankle. Now that same day,
Who told you that, by the way?
the father,
Okay, go ahead.
and I was coming back from the hospital that day. I wasn't nowhere near this incident. He said he put him in a playpen, and that was the end of this discussion. I didn't think about taking him to the hospital because, I mean, he got out, he was walking fine. He didn't limp or anything, so I didn't think of it. So I didn't do anything.
So there's no outward indication of injury, of a broken bone, at least?
Yes.
So how is it that from the shelter, the children went to the hospital?
Because the CPS lady asked me to take
What did she tell you as to the reason why?
to get a full body checkup.
Did she indicate to you that these kids look malnourished?
No, she didn't.
Okay. You indicated Navajo heritage on your mother's side, is that correct?
Yes, sir.
Any other response? Well, you're still at the shelter, is that correct?
Yes, sir.
You want the children to be returned to you at the shelter, is that correct?
Yes, sir.
And I also told the court that we're requesting a bench trial. Is that also the case?
Yes, sir.
And we discussed everything that you want to discuss as far as the removal portion of this.
Yes.
I'm sure other attorneys will have questions for you, okay?
Mr. Brooks?
Not many. The child protection team at the U of M indicated one of your children has a flat head. Do you understand what the significance of that observation is?
Could you be more specific, please?
How would a kid get a flat head?
Laying on his back all the time?
Which would indicate what?
I don't know. Sleeping?
How about that the child is being neglected, ignored, not paid attention to?
No, that's not the case.
When these new bruises were observed that you testified to, you were in the hospital at the time, right?
Yes, sir.
And who was taking care of the children?
The father.
Not your mother and not your sister?
I don't have a sister.
Or your aunt?
And even if they did want to take them, he wouldn't let them. So technically, the only time they seen my kids is when I was home.
All right. That's all I have.
Ms. Heiss?
I have no questions, thank you.
Ms. Thomas?
Yes. Mr. Rosas, do you smoke marijuana?
Not anymore.
When did you last time?
Last month.
And have you been going to Hickman ER 3 to 4 times a week?
Yes, because I have a bad gallbladder and they were talking about removing it, but they won't because I am pregnant.
Okay.
They want to wait until I have her first.
Okay. And have you asked for morphine or other painkillers?
No, I've been actually refusing them.
Okay. Let's see. Do you recall the children receiving an early on intake back in November? Do you recall early on being involved?
Yes, and we did attend some
Okay.
until we end up moving again.
Yeah, let's talk about those moves. So there's an allegation here that anytime CPS becomes involved, you move. Is
It's
there
not
any-
always up to me. It's whoever is providing at that moment, and if he can hold a job down, then that's where we were.
When did you realize that N had seizures?
He had one, he was 3 months, but that's only happened once, and he hasn't had one since.
And prior to the children, CPS recommending the children go for medical appointments, did the children have an established pediatrician or anything like that?
Actually, before we took them to the hospital to view them, I had a Dr. Amy scheduled for one, and instead of going to there, we went to the hospital.
Okay.
Now, when we were gonna get discharged or whatever this was gonna happen, I was gonna reschedule it.
Regarding the broken leg incident, about when according to your recollection, about when would that have happened? So
May 4th.
Thank you. I have no further questions.
Redirect?
The children are removed. We discussed parenting time. You would like at least 3 times a week, 2 hours per visit, correct?
Yes.
And I think you'd also mentioned, we had discussed that perhaps Catherine Cobb may have the facilities to also be supervisors, correct?
Yes.
No further questions.
Right, Russ?
The child you're carrying today, do you believe that Mr. Terms is the father?
Sadly, yes.
Thank you.
Ms. Hines?
No questions.
Thank you.
I do have one follow-up based upon Mr. Brooks' question, Your Honor.
Go ahead.
I think Mr. Brooks may have hinted or said, or there's been some suggestion that his client is not the father to these kids. Is that
I
accurate?
said he's
Yes.
getting DNA, asking for DNA.
Do you have any reason to believe that he's not the father of these kids? Thank you. I'll leave further.
Any other questions?
No,
No.
Judge.
Thank you.
Can I
You
say
may
something?
return to your seat. You've had your opportunity to testify. Testimony, Mr. Brooks?
No, Your Honor.
Ms. Hines, anyone you'd like me to hear from?
No, thank you.
Mr. McFarland, did you have anyone else?
No, I do not, Your Honor.
Very well.
Well, hang on, Your Honor. One moment. No, Your Honor.
Very well. Argument then in closing, Ms. Thomas?
Thank you, Your Honor. As relates to removal, I believe that the testimony established today by probable cause or reasonable cause to believe that the children would be at a substantial risk of harm if they were to be in their parents' care and custody today. I think the failure to thrive is pretty salient. The children are gaining weight as they are receiving proper nutrition. I think that there might be an argument that no one knew, so why should mom know? But again, these children haven't received any medical attention during their lifetime. They don't have an established pediatrician to counsel parents on what is appropriate for child's nutrition. In addition, Ms. Miles had also indicated something that we didn't put into the petition, but also just this, she referred to it as docile temperament or demeanor, but I think that that is something we're going to need to monitor. We know that toddlers in toddler development, they're typically pretty mobile, active, reactive when they're hurt, reach out for caregivers, for comfort. And as this case will progress, we are interested to see how that looks in a stable home environment where the children are safe and their needs are being met. we are asking the court to issue that removal. And there are no other reasonable alternatives to protect the children at this point in time. The grandmother, who would have a power of attorney, is unable to physically care for the children given her medical needs. And then the family members that have been posed as potential placements are not appropriate given their own history and based on policy standards there. So foster care is the least restrictive environment for these children at this time to provide them with safety and ongoing care. So we do ask the court find that it is contrary for the children to be in their parents' care and custody at this time, pending further hearings on this matter. Thank you.
Mr. McFarland?
Well, Your Honor, my client removed herself from an environment which she thought was detrimental to herself and minor children. While at the Catherine Cobb shelter, the way there seemed to believe the child was malnourished. We didn't hear the worker testify that she personally thought that the child was malnourished or undernourished. So I'm not sure how a parent is supposed to know this if somebody who's trained agency that screens didn't know that, and a mother also has other kids. So I don't know how that would happen. We also heard testimony that when the child was taken to the hospital, that doctor actually was observing children for physical abuse by a parent. That was ruled out. So that's not there. The other issues, I think my client fully explained what's going on here. That she's escaping a bad relationship, that testimony in the report is that, and my client testified, it's there because she's moved away. She doesn't want anything to do with him. We've heard that testimony, it's quite clear. And so there's a motivation, a reason to get to blame her. I don't know that this individual, this aunt, is not suitable for seeing this child. We've heard testimony that they claim that she's not, but the reason and rationale behind it, I'm not sure that that is the case. I would like to have this aunt fully explored, at least a detail given as to why she's not acceptable. I'm not sure about surgery with the maternal grandmother, if it's going to be a short surgery, if she wishes to have the children, since the children have been with her for some period of time after she recovers, which makes more sense than going to a stranger's environment, Your Honor, to maintain a bond with family. Client is living in a shelter, which there are individuals there that provide supervision. Not saying not to the contrary, from the gallery. We would ask that children stay with my client in this environment at the shelter. The court does determine that removal is appropriate. My client does have, as is customary by this court, at least 3 visits per week. You understand, 2 hours per visit. You understand that these are going to be supervised. We'd ask that the shelter would also be at least considered as a supervisory capacity to do this. But until there's a jurisdiction trial, I'm not sure that's enough for removal. I think that my client's in a safe and secure environment where the children are going to be monitored, where she's going to stay. She has no place else to go. So definitely not back with father at this point. Thank you.
Mr. Brooks?
My closing comments will be far more succinct. Paragraph 14 of the complaint, last sentence. Mr. Turnus felt it would be in the best interest of the children that they be placed in foster care, as he believes neither he nor Angel should have the children at this time. When we get the opportunity to admit or deny that, he's informed me he's going to admit it.
Ms. Heiss?
Yes, Your Honor. The May 17th trip to the hospital gave us kind of a baseline, and that doctor said the children were okay. Mom was in and out of the hospital, it sounds like, until the children were taken to U of M and admitted, but she wasn't in the hospital the entire time. I would ask you to consider that the child was in the care of both parents. The children were in the care of both parents when we have a broken bone and underweight. So I believe that the requirements of MCR 3.965C to A through E have been met through the testimony today. Thank you.
Okay, thank you. All right, well, the court finds all interested parties were given notice for purposes of today's preliminary hearing. They've had the opportunity to look at the petition, the attachments, as have I. And I've been able to listen to the testimony of the caseworker who did her investigation, and much of it, even if the rules of evidence applied, would be admissible because they were statements made directly by the parents. Were also many of her own personal observations. So the standard required for one of these hearings is frankly rather low. For purposes of authorizing the petition, it's really just a probable cause standard, which has been met. There are indications by the admissions of the parent against each other that there is some physical abuse happening. Physical discipline and physical abuse are clearly separate issues, but when you have children that are exhibiting injuries at this level, and then the admission of the physical abuse, as well as allegations of physical abuse by each parent against the other, it's more than necessary information for me to find that there's been a violation of the statute for physical abuse. I also see the physical neglect in the management of the health of the children. The underweight issue is significant in that when they first admitted to the hospital, they didn't even make it onto the charts for percentages, and the fact that they have made some progress already in just the past couple of days, and there's no indication of any other reason that they would have been that significantly underweight is concerning, and I find it does constitute a violation of the statute. And also the fact that they never finished up on the early on services or provided any medical care for the children by way of a primary physician in order to understand that information better, as well as the failure to secure medical attention for what appears to be a rather significant sprain suffered by one of the children in the recent days. So I do find that all occurred in the care of the parents, one or both together at different times, and that there's been a violation of the statute, and both of the statutory citations, both B1 and B2, I am taking jurisdiction of the children at this time. I also find that there's, because of those same findings and that factual basis, that there is the need for the court to remove the children at this time. The failure to take care of these children, to feed them appropriately, and to physically abuse them certainly creates a significant and substantial risk of harm to the children, which is the criteria, the start of the criteria that the court needs to evaluate under C2. Custody of the child with the parent presents a substantial risk of harm to the child's life, physical health, and mental well-being. The court does find that has occurred because of the same facts and circumstances I've already cited. B, no provision of service or other arrangement except removal is reasonably available to adequately safeguard the child from the risk of harm. I agree there as well. The proposed caregivers are, one is in the hospital and the other cannot pass CPS approval. There are no relative placements or other safety plans available at this time that would be less restrictive. Continuing the child's residence in the home is contrary to the child's welfare. I agree with that for the same reasons I've already articulated. And consistent with the circumstances, I do find reasonable efforts were made to prevent the need or eliminate the need for removal of the child. That safety planning, visits to the doctors, but continuing physical discipline, which at this juncture, looks like it can't be differentiated between physical abuse and physical discipline. Definitely continues to create a significant risk of harm, and those circumstances are very concerning, to say the least. The attempts to educate the parents and to support the parents around those things were efforts that were made by the department that satisfy subsection D. Subsections E, conditions of the child custody away from the parent are adequate to safeguard the child's health and welfare. I agree. Our foster placements are all vetted by the department. And that is the least restrictive. I agree with Ms. Thomas there, measure at this time to safeguard the children's health and welfare. I never like putting them in foster care. I far and away prefer relatives, but in this case, I think it's necessary to utilize a foster care placement under the circumstances, for the reasons I've already explored. So I'm signing the order authorizing the petition as well as removing the children. Parenting time, I'll ask the department to have an FTM on that to arrange as much parenting time as necessary. I'm sure the foster placement is going to be willing to do that. They're all advised when they take that on that parenting time is going to be a part of it, as well as continuing to monitor the children's health, welfare, and reporting that to our caseworkers as well. We have the trial date set already. For August 5th, commencing at 9 o'clock. I'd like to set a final pretrial before that, wherein the parties would provide witness and exhibit lists, exchange those for any additional exhibits or witnesses that need to be named, so that we can make sure we have enough time on August 5th. I can offer to you, for purposes of that pretrial, the morning of Friday, July 19th. At 11 a.m.
We have an long case at 8, but it should be done, I think, by 11.
Thank you for letting me know. I didn't have that one on my calendar, and we like to try to keep track of those so that we don't double book it. All right. I will issue those orders.
What time was that, Your Honor?
11.
Thank you, the 19th to 11th.
Yes. So Ms. Heights, would you recommend that we block off until 11 to allow for that case upstairs?
Yeah, I can double check, and it would only be Miss Thomas and myself.
I think we'll be fine.
But yes, 8 to maybe 10 should probably be blocked off to be safe.
From the future.
Yeah, so we don't mark anything else.
Thank you.
Parenting time, Your Honor?
The department is asked to conduct an FTM on that. Address it at the pretrial if we need. Any other questions? Yeah. All right, thank you, everyone. Good luck. We're back on the record for the continuation of the pretrial. There's a few preliminary issues that the court was looking to have produced from the department, including information on vital records for the child, DNA testing, Native American heritage search information. So we'll tackle all of that as well as any other preliminaries after appearances.
Lee Heiss, lawyer guardian ad litem.
Deja Miles, Ms. Sasha Thomas, counsel for the department.
Michael Brooks, I represent the father, Jarrell Turnus.
Jarrell Turnus, the father.
Morning, Your Honor. Ariel Berger here covering for Michael McFarland, who I believe represents mother.
Angel Rosas for mother.
Thank you. Welcome back, everyone. All right, Ms. Thomas, let's go to you first for some answers to some of those things that were raised at the last juncture.
Thank you, Honor. The DNA testing was scheduled for July 26th. I'm not sure if it's been completed. I know that Ms. Smith is in the courthouse or the courtroom. I may have more answers regarding that. And then I'm sorry, what other, for ICWA, is that what else you asked for?
Yeah, and let's see what else. I think there was one other thing. Oh, yes, any vital record searches that were completed.
If Ms. Miles may have the answers to that, but I do not believe that I have anything in my records for those issues.
Very well. All right, counselors, any objection to asking Ms. Miles to answer those questions before we go further?
No.
No.
Very good. Deputy Ames, if you could swear in Ms. Miles, come out to our witness stand. All right, proceed it will.
Thank you. Ms. Miles, to the best of your knowledge, did the parties complete the DNA testing on July 26th?
To the best of my knowledge, I believe they have, based on conversations that I've had with Ms. Smith, the foster care worker.
Okay, thank you. And were you able to obtain any vital records?
We have not received any vital records back at this time. Our other worker, Jamie Dillon, she had sent those requests, and based on a conversation with her, she's not received those back yet.
Okay. And what state was that sent to?
From my understanding, I believe it was sent to California and Texas.
Okay. And then for the ICWA search, were those documents sent out appropriately? Do you have any update on that?
Yes, I believe we attached them when last hearing, and they did not have any Navajo or any ICWA membership in any tribes.
I'm just wanting to confirm that I missed that.
I don't have anything in my notes about any exhibits that were produced.
I don't, yeah, Ms. Miles, I don't have that. The only court report that I have in my records is from Ms. Smith.
Okay, it was sent shortly after Ms. Smith sent hers because she did not have the copy of them, so I sent them, but I can resend them.
Well, what I have is that we had inquiries and the certified records of the mailing that was received June 7th, 2024, which I think was at one of our very first hearings. But we were waiting to see if there were any responses.
Okay, so we did obtain responses. I must have not sent it correctly, but I can definitely resend those out for sure. I apologize.
And you're not talking about the entire search. Sorry for the interruption. I just want to clarify, but just the things we've received.
Yep, the responses we've obtained back from the tribes.
Thank you. Go ahead, sorry.
I'm sorry, Your Honor. I did look into a separate folder. So typically I have court reports in one folder. So the ICWA search documents that were returned, it looks like I did receive those on July 10th. So Your Honor, I can send these back over to the clerk's office for printing. It looks like regarding NT from the United Kiowa Band of Cherokee Indians, it's not, no eligibility. Regarding PT for the United Kiowa Band of Cherokee Indians, no eligibility. Regarding PT from the Cherokee Nation, I believe this would be. There's no eligibility. Oh, I'm sorry, it's the Eastern Band of Cherokee Nations. The same is true for NT through the Eastern Band of Cherokee Indians. Then the Navajo Nation, as relates to both children, neither are eligible at this time. And those are the letters that we received back so far.
Like there was a request for a specific relative to be investigated. Were you able to look at that, Ms. Miles?
So Ms. Smith, from my understanding, was trying to get the maternal grandmother to sign the releases, to get like background information to make sure she was appropriate. And as far as I'm concerned, what I know, to my knowledge, Ms. Rosas, the maternal grandmother, is not willing to sign those releases. Additionally, I had requested my own CPS records for Ms. Rosas and Mr. Turns, and during my investigation, when they sent their Texas records back, they also included maternal grandmothers. And based on those CPS records and her CPS history in Texas, she would be appropriate for placement.
Have you circulated those pieces of information?
Ms. Smith does have them, but I have not sent them to anyone other than Ms. Stasia. I believe has a copy of them as well.
And Your Honor, if I may clarify, I believe that is the large packet of documents that Mr. Brooks was complaining about.
Still complaining about.
All right, so Ms. Berger, do you know, did you receive that? Or if Mr. McFarland is giving you access to his information to know whether or not he's received that?
I have 10 documents that I received about an hour ago, and I've not been through all of them, so I'm not sure.
Okay.
I don't have anything that's as voluminous as Mr. Brooks is referring to.
Okay, he's got about a 3 to 3.5, maybe 4-inch stack of papers.
I would love to have it, but and it's on this case.
I think he probably give you his.
Sounds like it's up for grabs.
Wow. All right, Mr. Brooks. Let's take it easy. Just
calm down.
Yeah.
apology accepted. All right. So in short, could you tell us a little bit about what you found when you looked at that request to investigate the relative?
Yes, so I did skim through because the, actually the records I received is a little over 800 pages. Most of that is Miss Rose's, is the maternal grandmother's. Angel and I believe her sister were also placed into foster care. From my understanding, because reading other states' records are a little bit different than our own. But Angel and her sister were placed into foster care. From Miss Rosas, the maternal grandmother, had drug issues as well as she was in jail, and they were turned over to foster care. And it goes through some years, and at the very end, it stops giving specific details, but it does provide a log of what contacts were made by the workers. And there are dates at the end, I believe around 2017, 2018, where they were still visiting Miss Rosas in a foster home. And that's basically what I had got from that Miss Rosas, the mother, had spent majority of her underage years in foster home.
Did you hear that okay, Mr. Brooks?
Yes, I heard it. Thank you.
Questions based on my questions, Ms. Thomas?
No, Your Honor, thank you.
Ms. Berger?
No, Your Honor.
Mr. Brooks?
No, thank you.
Ms. Heiss?
No questions, thank you.
All right, looks like we may need some information circulated, Ms. Miles, including those research documents as well as the responses. We can count on you to do that before our next hearing.
Yes,
Do you have any indication of when the DNA test results might be back?
I'm not sure. Ms. Smith of foster care would have more information for that.
Anyone else you'd like us to hear from today, Ms. Thomas?
Thank you, Honor. Ms. Smith did prepare a pretty thorough court report for us before the last hearing, and I would like to get that into the record for you just to have an update on the children.
So that was provided before the last one.
Yes.
Thank you for your testimony. We were trying to proceed. Ms. Smith, it sounds like you're up next. Did everyone receive that proposed court report? Do you know?
I did, yes.
I did.
Last hearing, you provided a court report packet, and it included your report, a proposed case service plan that was signed by both parents, the DNA testing appointment, the psychological referrals for both parents, a drug screen for both parents, the trauma screening checklist for both children, and then travel authorization letters for the children to travel out of state with their foster parents. Are there any other documents that were circulated since you've provided these documents to the parties?
No.
Okay. And to the best of your knowledge, are there any updates or modifications that need to be made to the court report or any of those attachments?
A few updates.
Okay,
So
please go ahead.
both boys are now receiving early on services and early Head Start, as well as physical therapy at IV rehab for NT. Both parents were referred to Michelle Palmer for anger management. In the report, it said that they were referred to our agency. I wasn't aware that we no longer do anger management. So they are both working with Michelle Palmer. I did get an update that Angel is attending weekly sessions and that Jarrell, once he gets insurance figured out, that he will be engaging with her as well. DNA testing was on July 26th. All parties did attend. It normally takes a week to 2 weeks to get back, and the results are mailed directly to DHS. So as soon as they receive it, we'll be able to forward the results along. Still on the wait list for the parenting education. I did follow up, and hopefully in the next couple of weeks that will start. That's the 16-week foster care supported visitation program. Parents also are visiting an additional day. We added Mondays, so each parent sees the boys Mondays, Tuesdays, and Thursdays supervised at our agency.
And they, I just want to clarify from that, the parents are each attending their own parenting time, correct? Like they're not doing it together?
Correct, they're separate.
Okay. And I'm sorry, you said Tuesday, Wednesday, and Thursday?
Monday, Tuesday, Thursday.
Monday, Tuesday, Thursday. Okay, thank you. And how long is each parenting time?
Each day for an hour for each parent.
Okay, thank you. And those services, like the case service plan and the services that you've mentioned, the updates on, are there any other voluntary services that the parents are utilizing or have talked to you about?
Not to my knowledge. I know that Jarrell had mentioned that he was attending some classes at Care Pregnancy Center. I haven't received, information if he is doing that.
but like I said, the parenting education referral has been made on our end, so that's on hold. I don't want him to duplicate services if not needed. He did recently report that he had obtained employment, so that I'll be able to verify hopefully in the next week or so. There's a referral that hasn't been made yet, but for a psychiatric evaluation, that's something that the agency is going to be working on next.
And so generally the parents are voluntarily complying with services at this point?
Yes.
Is there anything other than what is contained in the court report that you would like to put on the record, or anything from the court report that you would like to highlight for the court? Did you hear me?
Yeah, sorry, I said no.
Oh, okay, I did not hear that part. Okay, thank you. I have no further questions, Your Honor, and move to admit the court report with the attachments.
Okay, objection?
No objection.
No.
Ms. Berger, any objections?
Your Honor, I'm just now getting that, so I can continue reviewing as we, I can review as we continue, and if I have an objection, I will let the court know, but I do not anticipate one.
All right, thank you. We'll circle back then. Mr. Brooks, questions?
I have no questions. Thank you.
Ms. Heiss?
Ms. Smith, are you willing to, those 3 visits per parent per week are supervised? May I have those supervision notes as you get them in?
Yeah.
I want to make sure that partnership stays strong. Are either parent employed at this time?
Not to my knowledge. Like I said, Jarrell had just reported over the weekend that he had obtained employment. So
Do you know if they are involved in any food services, housing services, any of those kind of benefits?
I believe they both received.
Okay, nothing further. Thank you.
All right, can you tell me again what exactly was submitted? Because it looks like it got a little mixed in as far as the court records go. Is it this one, the July 11th report, which has exhibits named
Yes.
A through H?
Yes.
Okay, and then I do have the ICWA docs. It looks like from July 10th they were submitted. Some medical records and mailing receipts. Did you submit those? I don't think you did. Did you?
No, I had only submitted just the court packet.
Okay, all right. So counselors, in your notes, what do you have that was submitted? I know I have the ICWA search documents in my notes, but what else do we have that came into evidence during the prelim?
Well, I believe we have the admissions and denials, or do we not?
We do not. Today is a pretrial. The preliminary hearing and the removal hearing was conducted June 7th. And then we were set for pretrial and trial from there with a request for a bench trial.
Well, I can tell you that right now, my clients advised me twice that he intends to admit the entire petition.
Great. Ms. Berger, did you want a chance to talk with Ms. Angel Rosas?
I do have some notes here that I'm reviewing, Your Honor, so I do have some questions for the worker.
All right, good. Do you have any notes about what was received at the prelim so that I can make sure I don't pull something into the file that I'm not supposed to?
I think so. Let's see. It looks
Judge, if you-
like. Go
I'll
ahead.
say if Ms. Berger doesn't have it, I do. It looks like we had the ICWA documentation or the notice that were sent, a U of M medical report, and then photos.
That's what I got. Ms. Heiss, would you concur?
Yes.
All right. Oh, and it looks like at some point somebody turned in these responses that Ms. Thomas walked us through verbally today. Okay. So, did you receive those, Ms. Heiss, by any chance?
You know, I just found an exhibit list and I bet you they're in here.
Looks like these were emailed out specifically and on their own on July 10th.
I will double check.
Right.
Okay, I think I do have these records electronically in a different file under witness and exhibit lists. I was looking under court reports, but regarding ICWA, I will look.
All right. Would you like a moment to do that, or would you like me to allow Ms. Berger to begin her question?
Yes, I'd like her to begin her questioning because the records are replete that, you know, Native American has been looked in all these other records that I'm already reading. So yes, I think we should progress with questioning.
Very good. All right, Ms. Berger, fire away.
Thank you, Your Honor. Ms. Smith, can you hear me okay?
Yes, I can.
My client wanted grandmother to explore for placement. Is that correct?
Correct.
And how has that gone?
She will, for our agency, she refuses to sign the necessary clearances that we need to get her out-of-state clearances from Texas. However, as Ms. Miles had reported, she had sent me those clearances that they ran, and she wouldn't be appropriate for placement due to her prior CPS history.
Okay. And who's refusing to sign, mom or grandmother?
Grandmother.
Okay, I see. Okay. That is the only question I have. Thank you.
Mr. Brooks.
You already asked me, Your Honor, and I said I had no questions.
All right. Very good. Ms. Heights?
No questions, thank you.
Excuse me, I'm sorry. Thank you very much. Take all I can get. All right, which parenting education program are they on the wait list for?
Orchards, the 16-week foster care support visitation program.
Are there any other ones that you could explore for?
Not that are as hands-on, but I feel like the parents need, the wait list isn't long. They've been on, I made that referral back in June. So they should be, we can reach out to them again, but they should be very close to getting started on that.
Have you been out to where they're living?
I have been to the home that they previously lived in together. Jarrell only lives there now by himself. I have been out to the home.
All right, and what did you find?
It's appropriate. There would be some safety concerns and some baby proofing that would need to be done. It's an upstairs apartment. The windows are at like floor level. Several of them had no screens, so that would be very concerning for boys. But other than that, the home at the time is very appropriate.
Okay. All right, last call for any questions based on my questions.
None, Your Honor. Thank you.
No.
No matter.
Thank you for your testimony. We return to you. Anyone else you'd like us to hear from today, Ms. Thomas?
No, Your Honor.
All right, counselors. So what I have then is the 3 inquiries that were sent on June 4th with certified mail receipts. I have the medical documents as well as the photos that were submitted at the prelim and used at the removal hearing. I have the responses. Looks like from all 3 tribes, or all three inquiries, denying any Native American heritage, as well as the court report and exhibits that were turned in to the court on July 11, 2024. Any objections to those exhibits becoming part of the record?
No objection.
None.
No, Your Honor.
Very well, they are then. Ms. Berger, do you want a chance to talk to Ms. Angel Rosas before we take the plea from Mr. Brooks' client?
Yes, please.
All right, how would you like us to do that? Would you like to, well, Ms. Angel, do you have a phone with you today?
Yes, ma'am.
Okay, so if you can step into the hallway and log into our Zoom room. Okay. We can do it 2 ways. We can connect you by phone, or we can connect you in a Zoom room so you can have a video conference.
By phone. I
Okay,
don't have Zoom.
okay. So concluded your conference with your client, who wishes to confirm that she wants to proceed to a bench trial, which has already been set. And Mr. Brooks, does your client still wish to enter a plea?
Yes.
Deputy Ames, if you could swear in Mr. Jarrell Turnus, please. All right, Mr. Turnus, is it true that you wish to admit to the allegations in the petition today?
Yes, ma'am.
All right. If you do that, giving up your rights to a trial by judge or jury, the right to have the petitioner prove the allegations in a petition by a preponderance of the evidence, the right to have witnesses appear against you and testify under oath, the right to cross-examine those witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand that be giving up or waiving the rights I've just indicated to you if you admit to the allegations in the petition?
I agree, ma'am. I do.
With regard to the consequences of that plea or admission, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea?
I do.
Deputy Ames, do you have a set of those
I do, Your Honor.
you can have, take with them? Thank you, Deputy. Mr. Turnus, is anyone making you admit to the allegations in the petition?
No, ma'am.
Has anyone threatened you with anything in order to get you to admit the allegations in the petition? Has anyone promised you anything in exchange for admitting to the allegations in the petition? You under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing right now? Would you say your decision to admit to the allegations in the petition is one you've made of your own free will? Ms. Heiss, do you agree that it's in the best interest of these children for him to enter a plea?
I do, thank you.
Very good. All right. So, Mr. Turnus, what is it exactly that you believe that your family could use some help with at this time?
A bunch of things. That's why we're going to help through CPS right now.
I'm having a little trouble hearing you.
Said a bunch of stuff like our housing situation, we're always living out on the streets. In tents, shelters. I want to make sure that I can actually stay in my place for a while to actually show them that I can actually get my kids. Actually have a structure.
All right. Is it true that at times your children may have needed medical attention, but you were unable or unable to do that to get them the medical attention that they needed?
Yes, ma'am.
Do you think that some parenting skill building would be good in order to improve the disciplinary tactics in your home?
Yes, ma'am.
Okay. And I'm reading through the petition, so I'm not going through all of the specifics in here, but basically what you're asking me to do, according to Mr. Brooks, is take all of this and basically review it as though it were true. Is that right? All right, so I don't need to review all these details with you. I'm just targeting some of the things that we'll be asking the department to look at when they put your case services plan together.
You really do have to speak a little louder. I'm sitting right next to you and I can't hear you.
All right, are there any other issues, Ms. Thomas, that you wanted to highlight for the record that you'd like to have addressed as the department sees it?
Your Honor, I just wanted to sort of, I guess, connect the dots there for the referral for anger management. I think that also is relevant for the petition purposes. I think Mr. Turnus has a very realistic idea of what his family is in need of, as he stated, that stability, parenting classes, getting more information, education on the medical needs of the children, ensuring that those needs are being met. And I think for the most part, that is the gist of the petition. I believe that the factual basis is sufficient. Thank you.
Ms. Berger, any position?
No, Your Honor, we would just ask for these further dates to be scheduled as soon as possible.
Very good. I think that it has been set. I can tell you that date was set at our last hearing, and I believe it's at the end of September. Let me look. Yeah, September 30th, commencing at 9 a.m.
Perfect, thank you.
Mr. Brooks, do you have any questions as it relates to the factual basis of the plea for your client?
None.
Are you satisfied with the advice of rights and the factual basis?
Yes, I am.
Same question, Ms. Heiss.
I am satisfied, thank you, Your Honor.
Very good. The court also finds the plea to be knowingly, understandably, and voluntarily made, with a full understanding of the consequences. I further find the record supports one or more of the statutory grounds alleged in the petition are true. Evaluating those and highlighting those areas that are going to be targeted for the case services plan does allow the court to find that the statute, specifically MCL 712A.2B1 and 2, have been violated, and the family is in need of the support and guidance and supervision of the Department of Health and Human Services to ensure that they are able to provide proper or necessary support for the children, including education, medical, and other care necessary for the children's health, and to help alleviate the substantial risk of harm to the mental well-being and physical well-being that has been raised as a result of parents' environment up to this point. That also implicates number 2, specifically that home or environment characterized by that physical discipline that raises to the level of criminality and neglect to some of their needs, as well as homelessness, are all things that the statute is intended to target so that the department can support the family moving forward. So that is what our court order will reflect. Now, obviously, we have the issue of paternity still outstanding. In other words, we haven't been able to officially declare you the legal father of these 2 children. And so I'm just letting the department know that before we proceed with disposition, we're going to need to have that information. I need to tell you that we're going to need an adjournment on that initial disposition if we have not had parentage established. But I am very willing to take the plea today, to count on the department to put those pieces into place for us when we come back at disposition, understanding that the family does want to get involved in some services and get started on the plan. All right, anything else for the record today as it relates to the plea adjudication?
No, Your Honor, thank you.
Has the court received a jury request for our trial in September?
I have not. I have it scheduled as a bench trial. Okay. And there was an indication in the last court order that any request for jury trial did have to be made within 14 days in writing.
Thank you.
And I believe that was also visited at the last trial. So. All right, we're going to set the disposition for Mr. Turnus to commence at the outset of the time previously set for the bench trial. So September 30th at 9 a.m. Schedule Mr. Turnus's initial disposition, assuming that all of the pieces are in place. That is a few days outside of the 28-day time frame, Mr. Brooks. So I'm happy to move that up if you need, unless you wish to waive that for your client.
I'll waive it, Your Honor. I don't think it means a whit of difference in my client's case.
Would you agree that that's in the interest of the children, Ms. Heiss?
Yes.
Very good. All right. So, Mr. Turnus, you've already seen the case services plan, as I understand it, which is great. That would have been the subject of a meeting between now and when we come back. You may still have a meeting on some of these issues that are outstanding, but just keep your caseworker up to date on your progress. And we'll see you all back here at 9 a.m. on September 30th, unless there's any questions.
Your Honor, I have visited the children during a visit of the parents, and I would indicate that their needs seem to be met at the placement, and the parents are visiting 3 times a week, an hour each for each parent, and that to continue with that at least for another review period.
Thank you.
Thank you.
For emergency removal 4. All right, we're on the record today in this case, following the request for an emergency removal, which the court granted over the weekend, last weekend, of the newest child born to this family. So this prelim follows that order in accordance with the statutes. Many of the questions that are typically asked of a family at a prelim have been answered by this family already, but we'll go through some of those as well. In addition to reviewing the removal and the placement. May I have the names of our participants, please?
Lee Heiss, lawyer guardian ad litem.
Ms. Tasha Thomas, counsel for the department. Ms. Young.
Caitlin Young, Department of Health and Human Services.
Michael Brooks, I represent Jarrell Turnus, the father, well, right now, putative father of the newly born child.
Is your client here?
Yes.
Oh, yes, okay.
He's here?
Yeah.
He is here. Would you mind?
Scoot over one.
Sure, or he can pull up a chair next to Mr. Brooks over there if he wants to.
Sure.
Ms. Young there. That works good. That way I can still see Mr. McFarland. Who's next?
Michael McFarland, representing mother, please introduce yourself.
Angel Rosas. Thank you, welcome. All right, Mr.
I think he
McFarland.
has to introduce himself too.
Jarrell Turnus, the father of Andrea.
All right. Well, while we're on the subject of legal parentage, Deputy Inspector, swear in Mr. Turnus and Ms. Rosas. Did you fill out an affidavit of parentage or anything at the hospital that would confirm whether or not you are the legal father of this child? No?
I actually found out over a message from my daughter that she was born.
All right. Are you interested in DNA testing, or what are your intentions as it relates to this child?
DNA testing.
You request a DNA test. Thank you for clarifying. Have you received a copy of the petition that was filed?
Yes.
All right. Okay, well, let's go to your client next, Mr. McFarland, with some of those same questions. Ms. Rosas, do you believe there are any other potential fathers other than Mr. Turnus for this child? No. All right. And do you have a copy of the petition? Yes, ma'am.
I provided her with that.
Why don't you update the record, Mr. McFarland, on the placement request that you informed us?
Your Honor, in the petition, the other children, it was stated that my client's mother, they acknowledged there was a delegation of parental rights, but due to medical purposes, she was unable to exercise that. My client's mother will be testifying today, is the belief that she's been cleared by the doctors and she is able to take care of children, and my client would like her to be considered. I've spoken to her. She does wish to have placement. My client also does have a document from the hospital, which she has on her phone, which we'll try to share with everybody. She just pulled it up, which shows that she tested negative for all drugs in her system at the time. But it's negative for opioids at the hospital. So we are asking for a bench trial if the court does authorize the taking of this child in placement for protective custody, that these two cases proceed together at the same trial.
In Texas.
All right. Thank you. Well, and things can't really proceed as it relates to Mr. Turnus as far as trial or bench trial or anything else until we've established that legal parentage piece. Ms. Thomas, preliminaries from your perspective?
Thank you, Your Honor. As it relates to the preliminary hearing and the proofs that need to be put on, I would ask that Ms. Young be sworn in for that purpose.
Yes. Just swear in Ms. Caitlin, yeah. Right, Ms. Thomas, proceed at will.
Thank you, Your Honor. Ms. Young, can you briefly state how you are familiar with this matter?
I was serving as the CVS on-call worker for this last weekend, and I was made aware of a complaint that had come in on Friday stating that Ms. Rosas had the baby, and I went down to make face-to-face with the family.
And you completed the petition that is before the court today, is that correct?
That is correct, yes.
And I know your role as an on-call worker sort of varies depending on what issues arise. But in this case, you is it accurate to say that you are also sort of an investigator for the petition?
Yes.
Okay. And as you investigated this matter or the complaint that was submitted to the department, what steps did you take to determine whether there was a risk of harm to this child?
There was multiple steps that I took. So I reviewed the prior petition prior to going down to interview with mom. Because it was my understanding that there were 2 other minor children that were removed just within a couple of months of the baby being born. So I did review that and met with my supervisor, developed a plan to go down, assess the situation to kind of see what steps mom was taking to be proactive to try to eliminate the barriers from the other petition. So I did that. I also made some observations and spoke with hospital staff to gather additional information throughout Friday as well as Saturday morning, receiving more phone calls with additional information.
And what exactly did you learn through your investigation process or your time with this family that made you believe a petition was necessary and that the parents, specifically Ms. Rosas, would pose a risk of harm to this new child?
In reviewing the other petition, I was just kind of made aware of some of the concerns that were outlined with that, with the physical neglect, physical abuse allegations, as well as the malnourishment of the other 2 minor children. So when I went out, I was just kind of looking at the situation from multiple steps. So I wanted to make sure, mom was equipped to be able to manage the care of the baby, to make sure that she had safe and stable housing, making sure that she had all the equipment, everything that she needed for baby, as well as observing her with the minor child. While I was there, I was able to make some of those assessments as well as speak to the hospital staff that's also observed her and made note of that in the petition.
In the petition, there are some notes, or there's allegations that mother was struggling to feed the baby or identify with the child's needs despite having young children who were, newborns or needed newborn care more recently. Can you tell us more about that?
Yes, so that was an observation that I made as well as the hospital staff. Mom appeared to be very kind of on edge. She was a little frustrated at times. She was trying to get the baby to take the bottle. After about a minute or 2, she would get very flustered and then would pass the baby off to the nurse that was in the room. And there was a lot of concerns throughout the night after I left and throughout that morning. And it was observed about 2:17 a.m., according to the nursing staff, that they had walked into the room and observed mom to be yelling at the baby and trying to give her the pacifier. And she had indicated to take the effing pacifier. And mom was seen to also be physically aggressive with the baby, trying to get clothes back on her. So there was some pretty notable concerns that not just what I had observed as far as the feeding, but also what hospital staff observed throughout the night and throughout that morning before I went back down to the hospital.
Was this baby born to term?
The baby, from my understanding, was 38 weeks and 3 days gestation.
About how big do you know was the baby at birth, weight-wise or length?
I believe she was about 5 pounds, 1 ounce, and 18.5 inches long.
So fairly small, newborn?
Yeah, she was very small.
Were there any other concerns about Ms. Rosas's understanding or knowledge of proper feeding schedules, routines for newborns?
There was a lot of observations on that, and a lot of questions asked by herself as well as her mother, Crystal. They were questioning like how often the baby should be eating, how much the baby should be eating, and trying to figure out why the baby wasn't taking more than what the nurse was indicated should be appropriate for a baby of that size and being a newborn. So myself and the nurse was trying to explain to both mom and the grandmother that, when the baby's born, their stomachs are very small. They're not going to be taking a lot of formula in at any given point. It's a smaller amount, but they have to have frequent feedings every 3 to 4 hours as recommended. And we had to reiterate that a couple of times. I know the nursing staff was trying to engage throughout the night and the early morning. But she'd become very irritated after a minute or 2 of trying to feed her. We went through various nipples for the bottles before finally getting a smaller one to try to initiate some of those feedings, which needed to work out a little bit better. But there were still some questions about that feeding, considering this is her 3rd child in the last couple of years. So hospital staff noted that someone who has had 3 babies over the course of 3.5, almost 4 years should have that basic knowledge and understanding of how to feed a newborn.
In your opinion, do these concerns that you've just testified to arise to the level of posing an imminent and substantial risk of harm to the child's life, physical health, or mental well-being if Ms. Rosas was to remain the primary caregiver for the baby?
In considering the fact that there were other 2 children that were previously in her care that were failure to thrive, and with the present concerns of being unable to understand or have a basic understanding of proper feeding of the child, yes, there was imminent risk of returning that child to her care. One
of the things the court must consider the reasonable efforts made to prevent removal. Is that something you can testify to as to what services were offered to Ms. Rosas in the recent past that might have assisted her in understanding typical child development or how to interact with a newborn?
To my knowledge, in speaking with mom, she is participating in services to the domestic violence shelter. She's also receiving services to the Care Pregnancy Center. She indicated that she was in therapy services, parenting education, anger management. So all of those services, really can kind of help with her situation as far as caring for young children. At the Care Pregnancy Center, that's specifically what they do, is they're providing services to that aspect. So she was also receiving education through the hospital as part of their requirements, providing safe sleep information and so forth. So they were constantly providing that education even after the baby was born.
And I believe that Mr. McFarland has already alluded to this. So is there a relative who the department has determined is appropriate and willing and able to take placement of this child?
At this time, there was 2 relatives that mom had identified that she would like to have explored, both of which were found to be not appropriate by the investigative worker who was assigned to the other 2 children. Her mother, Crystal, has an extensive CPS history in multiple states. So I know we have an 880-page document from the state of Texas in regards to
I'm objecting, Your
CPS
Honor.
history.
That's not on this petition. That's not on the prior petition. The prior petition only covered medical issue with my client's mother. It's not on this petition or the other.
Well, Mr. McFarland, this is the same petition. Okay, well, it's a petition 2, but it's the same family, it's the same relatives. Say is something I can consider at this particular juncture. Ms. Thomas, did you want to add anything?
Yes, Jenner. We typically don't put allegations of placement into the petition. It's a policy that we explore relative placement within the first 30 days of removal, if that's appropriate. And so I believe, and additionally, I believe that Mr. McFarland opened the door when he made his opening remarks about this issue as well.
In response, Your Honor, I was just quoting the prior petition as the only reason they found my client's mother not appropriate. They mentioned that there was a delegation of parental rights on the other children, but that my client's mother was not physically capable. It's the only paragraph in there that I recall that addressed the unsuitability of my client's mother for placement. There's no other mention in this petition or the other petition, so laying a trap for us, and that nobody knew about that this was coming because they found her acceptable in the other petition, except for a physical issue.
Any position, Mr. Brooks?
No position, Your Honor.
Ms. Heiss?
I think we litigated this regarding placement on the other children. But I think there's a duty of the department not to publish and to file the CPS background of the other potential placement. That I have nothing further.
Thank you. I'm going to overrule the objection. There was a hearing wherein the placement with your client's mother was thoroughly explored and addressed. Mr. Brooks, as you may recall, was understandably perhaps upset about the amount of documents involved with that particular background check.
You got the tense wrong, Your Honor.
Oh, was versus is.
I'm still not happy with this.
Yes. So we do have a lot of information about this particular request for placement, and it is certainly relevant to Mr. McFarland in order to really look at your client's request to have her mother considered for placement. So for all those reasons, I am overruling your objection. All right. The next question you have, Ms. Thomas.
Thank you, Your Honor. Ms. Young, at this time, where's the child currently placed?
The child's currently placed in in a licensed foster home through Catholic Charities. The caseworker, Kristen Smith, will be taking over as far as case management for this minor child as well as the other 2.
To the best of your knowledge, is this the same foster care home as the 2 other children?
It is not, no. The other home was not able to take the baby for their licensing, from my understanding, at least from what I was informed.
Okay, thank you. And then as it relates to parenting time, that would also be something that the foster care worker would be better suited to answer. Is that correct?
That is correct, yes.
Okay, thank you. Your Honor, as it relates to the preliminary hearing, I have no further questions for Ms. Young.
Mr. McFarland?
How many hours after the birth of this child did you make your observation of my client in the infant?
The baby was born in the middle of the night around, I want to say around 1:34 a.m. or approximately around that time. I went out to the hospital closer to about 6:30 in the evening after I received the complaint.
How many hours was my client in labor?
I don't know.
So you don't know whether she had been up all night and was perhaps grumpy in the morning, having been in labor all day. You wouldn't know that, right?
I would not, because I was not there.
You identified yourself to my client that you were with Child Protective Services from Lenawee County, correct?
Correct.
Wouldn't you expect a client then to know that she's under the microscope of Protective Services to ask every single question possible, especially if she has a prior pending case, so she knows exactly what the expectations are for a newborn child? Do you think that's unusual?
The unusual part about it is that she had just had 2 other children within the last couple of years. So anyone who had had that amount of children within that small amount of time frame should have a basic understanding and knowledge to properly care and feed for a newborn. So I do find that a little unusual under that circumstance.
Now, a lot of what you have here is hearsay, and I realize that's admissible, but you have in your notes what hospital social worker you talked to, correct?
I have the first name. I did not get a second, or the last name of the hospital social worker.
Is that typical protocol that when you talk to somebody and quote what they're telling you, that you don't take a full name?
Not typically, but that was all the information that I was allotted at that time. I can conceivably get more additional information if needed.
You indicated other nurses, the nursing staff made note of things to you. Do you have the names of the nursing staff that you spoke to or you're taking notes from?
The notes were directly out of the case file that the social worker was reading to me. So I don't have the names of the nurses. That would be requested through the CPS investigators who would be requesting those records.
So will you share those files with us as soon as they're obtained?
I will make note of that to have the investigative worker do that.
Also, you indicate here that hospital staff indicated that my client was testing positive for controlled substances during the pregnancy. What are the names of the workers that told you that?
Again, the hospital social worker provided a majority of this information. And that was directly out of the notes from her hospital stay.
So basically, she was telling you hearsay upon hearsay, if I understand, is that she was telling that in this report, this says something, and then she was then telling you and you're now telling us, correct?
I made note of the information and concerns that was brought up by the hospital.
Doesn't answer my question though. My question is, it appears as though this is coming from multiple hearsays. Would you agree?
I suppose so, but it's all part of the hospital records.
No, I'm not denying that. But we don't have any names of anybody for me to question or that you can provide to the court regarding the veracity of this, correct? You don't even have the records with you today, correct?
I do not have a copy of the records. We have to request those from the records department from the hospital directly. That's not something that they can just readily hand over to us.
So when did you request those records?
I'm meeting with the investigative worker to try to come up with a plan to get those records.
So you haven't requested those yet, correct?
I have not directly myself. I received the information over the phone that there were concerns, and that's the information that I have. The records will have to be requested.
Are you aware that there's documentation from my client that she tested negative for opiates? As far as when the child was born, are you aware of that as far as the hospital records?
I am aware that she only tested positive for THC and but had prior.
So how much THC did she have in her system?
I cannot attest to that. I don't know the levels.
So you have no idea whether this THC would affect her or not because you don't have anybody
Your
reporting.
Honor, I'm going to object to this type of questioning. I believe that it's better suited as an argument rather than questioning. Ms. Young has not reported or claimed to be a medical professional regarding that level.
Well, Your Honor, there is in the report about that my client tested positive for THC at the time of birth. So if that is not an issue and they would agree to withdrawing that, I'd be fine. If not, I think I'm at least allowed to ask what percentage of THC elevates this to a concern. What did my client have in her system? If they don't want me to address this, then I don't have any objection to removing that.
Any position, Mr. Brooks?
I take no position, Your Honor.
Ms. Heiss?
But the person is a pregnant person, so any trace, we're not interested in the effects on her. We're interested in the effects on the other human that was inside her body at the time that she tested positive. So I think it's any trace even amount is important, and we will get the amounts when the records are available.
Thank you. I'm going to sustain the objection, Mr. McFarland, and just note that this is a probable cause hearing to determine whether or not there's a risk of harm associating with allowing the child to remain with the parent. And you are welcome to exert your level of confidence and questioning at the bench trial. And I think that's very appropriate for that, considering that the rules of evidence would certainly apply at that juncture. But for purposes of today, I'm going to ask you to move along with something.
Well, one more question then. You indicate there are no test results on the child as of the time of birth for any substances. Do you have those results now?
I have not received those results as of yet. They were still pending from when I met with the hospital staff on Saturday.
Oh, did you call today to find out what the results were?
I have not, no.
No, it's been almost 8-hour day. Is there a reason why not?
I have not had a chance to request any of those records.
While we were waiting to start, you couldn't have done that in half an hour?
Your Honor, again, I'm just going to object to this line of questioning. Again, I believe that this is more appropriate made as an argument. Like this is badgering Miss Young. She was on call. I don't know that anyone understands what it's like to be an on-call social worker, working 24 hours a day, going to hospitals, meeting with people, writing a report, answering to me and all of my questions. But this line of questioning, I would argue, is surmounts to badgering.
Your Honor, she testified that there's no time, and I think there probably was time to place a simple call like that. If that is an issue, at least in the report, if it hasn't been done since Saturday, and here we are on Monday. I think the court sees where I'm going, so nothing further.
Well, any position, Mr. Brooks?
No.
Ms. Heiss?
No, thank you.
I am going to sustain the objection, same as I did before. Mr. Brooks, do you have any questions for this witness?
A couple, Your Honor. You are familiar with the couple seated to my right and to my left, right?
Yes, I was made aware through this investigation of who they were, yes.
Are they married?
To my knowledge, no.
When the child was born, was any effort made at the hospital to get an AOP signed to establish parentage for this child?
At the time of my investigation, when I met with mom, it indicated that she was filing a PPO and had done so with the advocate from the Domestic Violence Center. So when I reported back and met with the hospital staff, they had indicated that there was no name on the birth certificate. And that was something that mom did not wish to have him on there at that time. She didn't want him to be aware that he was, that she'd even had the baby because she had filed a personal protection order. And that's what she had indicated to me at the hospital.
So nobody mentioned that an AOP was signed by this couple?
No, and I had discussed with her about different steps that need to be taken, as well as the nurse that was on call, the nurse in charge.
So as we sit here today, the paternity of the child with respect to the father is unknown.
That is correct.
That's all.
Ms. Heiss?
In reviewing the other case that's pending with other 2 children, did you note any broken bones in that case?
I did read that in the prior petition that was made, I was made aware of that, so yes.
Thank you. That's all I have today. Thank you.
Any redirect?
No, Your Honor.
Thank you for your testimony. You may return to your seat. All right. Well, there's a few other things under the court rule that we need to visit with your clients, gentlemen. First of all, of course, I want to remind them that they each have the right to have the petition read onto the record. Would you like me to read it, or would you like to waive that, Ms. Rosas? Thank you. All right. So page 1 indicates the petition 2. Second page indicates in paragraph 3, there are no other pending or resolved cases concerning the child that we're aware of. And number 4 alleges that 2 sections of MCL 7128.2b 1 through 6 have been violated, specifically that the parent or other person legally responsible for the care and maintenance of the child, when able to do so, neglected or refused to provide proper or necessary support, medical, surgical, or other care necessary for the child's health and morals, or that he or she has subjected the child to a substantial risk of harm to his or her mental well-being, or has abandoned the child without proper custody and guardianship. Second allegation of violation of the statute includes the home or environment by reason of neglect, cruelty, drunkenness, criminality, or gravity on the part of the parent is an unfit place for the child to live. Paragraph 5 indicates the reasons why it's necessary, why it's contrary to the welfare of the child for the child to remain in the home. It indicates Andrea is a newborn preemie baby. She will need specific care and attention to ensure she meets developmental milestones, which the parents have not demonstrated an ability to provide. In June 2024, the respondent parents' 2 older children were removed from their care and custody for physical neglect, medical neglect, and threatened harm of physical injury. And 2 older children were hospitalized due to failure to thrive because of being underweight. One of the minor children also had unexplained injuries. Neither child was found to have any physiological reason for failure to thrive. Findings were consistent with physical and medical neglect. To date, the parents have not addressed the reasons the older 2 children were removed. Paragraph 6 is checked and indicates the reasonable efforts made to prevent the removal of the child include foster care case management and voluntary services early on, CPS investigation, safety planning, child medical evaluation at Hickman ER, U of M Child Protection Team medical evaluation, family team meeting, Catherine Cobb and DV resources, gas cards, diapers, wipes, and baby supplies, as well as bridges assistance, therapy services through Catherine Cobb, as well as anger management and parenting education through Catherine Cobb and Care Pregnancy Center. Paragraph 7, the specific allegations are, A, on 8/9/2024, respondent mother gave birth to Andrea Rosas at 1:43 a.m. It is reported that Angel was positive for THC at the time of birth. Andrea's meconium is currently pending results. B, while under observation by nursing staff and CPS on-call worker Caitlin Young, it was noted that respondent mother struggled to feed the baby and appeared to struggle with identifying the baby's needs despite having 2 other children within the last 3 years. C, hospital social worker attempted to engage in conversation with the respondent mother, in which it was noted that the respondent mother became agitated with the social worker and kicked her out of the room. D, it is reported by nursing staff the baby was exposed to THC and opiates in utero, as reported through testing throughout the pregnancy. Nursing staff expressed concerns with the extensive drug use. E, respondent mother acknowledged she had access to services through the DV shelter, such as individual weekly therapy services, anger management classes, parenting education, and assistance in filing a PPO on respondent father due to DV concerns. F, on 8/10/24, on-call worker received a call from Toledo Hospital social worker Monica. The respondent mother was observed throughout the morning to be on the bathroom floor, vomiting and dry heaving. Nursing staff made note it appeared she may be exhibiting withdrawals from THC, although mother reports a history of gallbladder issues. Hospital social worker noted that at 2:17 a.m. on 8/10/24, nursing assistant entered respondent mother's room and observed mother to be forcibly trying to open the baby's mouth and putting in a pacifier. Respondent mother was overheard telling the baby to, quote, take the fucking pacifier, quote. At that time, the nursing assistant attempted to intervene and assist the mother in the baby. H, respondent mother was then observed to be changing the baby's clothes and was observed to be overly aggressive and becoming extremely agitated towards the baby, who was noted to be crying. Nursing staff then proceeded to take the baby from mom and transported the baby to the nursery for further observation and care. I, hospital social worker, also noted that there were continued concerns with respondent mother's refusal to care for the baby throughout the night and extreme agitation towards the baby and staff when attempts were made by respondent mother to try and feed the baby. Attempts were made by respondent mother for a very short time, about 1 to 2 minutes, before she gave the baby to nursing staff to take over the care of the baby. J, hospital social worker further stated that the nurses made note of concerns that respondent mother does not have a basic understanding of proper feeding of the baby or knowledge of why babies need to be fed as recommended every 3 to 4 hours. K, there is great concern that Andrea will suffer abuse and neglect if discharged to respondent mother's care and custody. Paragraph 8 indicates I request the court to authorize the petition, take jurisdiction over the child, and issue an order removing the child. Signed by Caitlin Young and Nastasia Thomas. At this point, the court reviewed this petition, which came in on Saturday by email, authorized the petition and the removal hearing, and this hearing follows. Ms. McFarland, your client has the opportunity to admit or deny each of the allegations in the petition. Also, obviously, the right for a trial on the allegations of the petition by bench or jury. Have you talked with her about those rights?
I have. She admits she's a mother. Other than that, we wish to have a bench trial, Your Honor.
Very well. I'll just remind you, and it'll be in the order, that if you change your mind and would like a jury, you've got 14 days to put that request in writing. Mr. Brooks, same questions for your client.
No, we do not need the petition read.
All right, your client has the opportunity to admit or deny any of the allegations in the petition, which don't appear to really concern him at this point, but does he have a position on that?
No, I mean, there's nothing for us to answer for.
Very good. Are you requesting a jury or a bench trial on petition 2?
Let's wait and see what the paternity shows.
Very well. So we'll simply adjourn, or maybe what we'll do is we'll set a pretrial for your client.
Well, we can set a pretrial so we know what the progress is on getting the DNA results back.
Yes, it's been scheduled. Ms. Young, maybe you don't have the answer to this, but I know there's been a DNA test scheduled for Mr. Turnus with, I think, at least one or both of the other 2 children. Would it be possible for them to test all 3 children?
I will look into that with the investigative worker and the foster care worker that's assigned, and I'll let them test that. They should be able to get everything scheduled.
Your Honor. Ms. Smith, please don't speak. Your Honor, if I may just give you an update on that point.
Go ahead, yes.
Thank you. So Mr. Turnus and the 2 other children did participate in the DNA testing at the end of July. Right after our last hearing, we did receive those results, and we're going to submit them to the court at the next hearing for him, with the understanding that that was required given he did enter a plea as relates to the other 2 children.
Thank you. So we'll leave it to whoever needs to tackle that to look at whether or not those same DNA results can be used to facilitate the DNA testing of this child. Does that sound fair?
Yes, Your Honor, thank you.
All right. Obviously, Mr. McFarland, your client's been consulted on who she would prefer for placement. Is there anyone else that she would like us to consider?
She will ask around, Your Honor, but it occurs to me if there is some question who the actual father is, then there may be some question whether there's Native American heritage if we don't have a father. So I'm just raising that question right now for everybody.
Well, what I have, Mr. McFarland, and correct me if I'm wrong, is that Native American heritage search has been conducted for both of our parents, and the tribes have denied any eligibility or current membership as of today.
Right, but I'm saying that if putative father is not the father, then that issue may arise. So I'm just letting you know.
Thank you. All right. Your client also has the right to seek placement independently of who she would like to have. Is your client asking for placement today, Mr. McFarland?
She is, Your Honor.
Thank you. Mr. Brooks?
No, Your Honor. I assume that my client has no issues with the foster care that the child's in. Am I right? He's just affirmatively responded to what I said.
Very well. All right, I think that's it for the preliminary issues according to the court rule. Ms. Heiss, are you ready to give us any comments about your thoughts on placement or the current situation?
Yes, Your Honor, I think the family needs to be researched early in the first 30 days, and after that, we will be satisfied with the placement where the child is, but at this point, I don't hear any viable options for relative placement, but we will have to look into that, and you know, the concerns for the other children, to see those same concerns here is alarming. Thank you.
Very well. On placement, your position, Ms. Thomas?
Thank you, Your Honor. I believe that the contrary to welfare findings, we would ask the court to continue to find those. And as it relates to whether the conditions away from the parent adequate to safeguard the child, at this point in time, the foster care placement seems to be the least restrictive, provided that we were unable to approve the maternal grandmother for placement of the other children after reviewing the CPS history, notably in Texas, and how large that document was. So we are just asking the court to continue placement outside of the mother's care and custody with a licensed foster care home.
Argument, Mr. McBride.
Yes, Your Honor. Now, if we had the records here, it would show that my client was at the hospital for 15 hours for the birth of this child. I can imagine hours after giving birth, and she's going to be in a normal state of mind. I don't think anybody would be. I also think that it'd be a reasonable expectation that if you're under active investigation by Child Protective Services, that you would want to know, especially since you talked to your attorney, what the expectations are. And so she's asked for the expectations for birthing, so she knows exactly what they are. I don't think that's unusual. I think under these circumstances, that's appropriate. I know hearsay is allowed, Your Honor, but we are getting into hearsay upon hearsay upon hearsay. The records are reported to the worker, the worker reports to us. I'm not sure about the credibility. We heard the worker state that I'm not sure that it's reasonable that from Saturday till today, before we began this hearing, that a call couldn't have been made while we were waiting to find out if there are any test results on the child. As far as anything in the system that's harmful to the child. So it's a question mark that's out there. I don't think that burden has been met. I think it could have been met since Saturday. So my client advises me that she will be contacting all family, and within 24 hours, she would like to know who she should report possible people for placement. She's also asking for regular visitation. And I think a newborn really does need more of a bond than an older child. She would like to see the children that she's visiting right now start to form a bond with this child. She would also like as frequent of a bond as possible with the newborn. So we are asking for very liberal parenting time, Your Honor. There's a great deal mention of the prior charges against my client, but that's what they are at this time. We have a trial. So to hold necessarily in the closing remarks that against my client, I realize they're going to do that, but that's not evidence that she's a neglectful or abusive parent just because it's been filed, as we've seen before in cases. So we'll rest with that.
Mr. Brooks?
My client is in complete agreement with what the department and this court has done recently with the two older children, older in quotes. The players are the same, the situation is the same, and he has no objection to what it appears you are about to do.
Ms. Heiss?
I do think the burden has been met, and the child's in a licensed foster care for the time being till we can work these things out. I think that's appropriate. Thank you.
The court finds all interested parties were given notice for purposes of today's prelim. I was able to review the petition as well as I am familiar with the file with the older two children. At the time the petition 1 was filed, that was just June 6, 2024 of this year. We just recently had Mr. Turnus admit to some of the allegations of petition 1. As a part of that, we had allegations from both parents indicating physical abuse by the other parent, indications of physical evidence of that by significant bruising on the children. One child had a serious sprain that the parents failed to seek medical attention for, and both children were significantly underweight. Parents didn't have medical care for the children to have attention to the deficiency. Mother had admitted very recently to using THC. There's a very good chance that this child was born positive for THC as well, which obviously may affect her ability to take a bottle or to feed or to develop in a healthy way, which is certainly a risk of harm. The other allegations are also very concerning as far as the physical aggression observed towards this infant child who is a prematurely born, very small child who likely is also going through withdrawals from THC and struggling to make her way through the beginning days of her infancy. So there's clearly some danger here in allowing this child to stay with the mother pending further proceedings. I made those findings at the outset of my review of the petition, but I am confirming them now for the record. I do find custody of this child with mother or father does present a substantial risk of harm to this child's life, physical health, and mental well-being at this time for the reasons I've already cited. I find further no provision of service or other arrangement except removal is reasonably available. The requested relative placement has been investigated. There are significant concerns in awarding placement to the family members in this case, and that's been the subject of much conversation in prior hearings, which is in the same file, and I have no reason to say that I couldn't look at that information when I'm trying to decide what's safe for this child moving forward. Certainly for the same reasons I've already discussed, continuing the child's residence in the home of mother or father at this time is contrary to her welfare. And we had lots of information about the reasonable efforts made to prevent or eliminate the need for removal, which I agree with Ms. Heiss causes some concern that we have been looking at this case at least since June 6th, 2024, and we're still seeing some very concerning indications of mom's parenting being a risk to this child. Child away from the parent are adequate to safeguard the child's health and welfare as of today in an unrelated licensed foster care placement. That's been investigated by the department and deemed to be safe and sufficient for the child at this time. So for all those reasons, the court's findings remain firm in removal. This child is in the safest and least restrictive environment right now. We have our next court date set is September 30th, beginning at 10 a.m. That is set for the initial disposition as it relates for Mr. Turnus on petition 1. We'll set it for a pretrial on petition 2. I'm going to order DNA testing for this third child against Mr. Turnus. Also, record hopefully, which is already out there, so that paternity can be thoroughly investigated. If Mr. Turnus is determined to be the legal father, that certainly satisfies all of our need for investigation into Native American heritage, since that's already been completed and denied. As it relates to Ms. Angel Rosas, we will also set petition 2 for trial on the 30th, commencing at 10 o'clock, and I have the whole day reserved for this matter, petition 1 and 2. So we'll get through as much of this for this family as we can on September 30th, starting at 10 a.m. Are there any other issues that need to be addressed for the record today?
No, Your Honor.
Parenting time for my client and newborn and the other children.
Are we able to ask our foster care case management person to conduct an FDM on that question?
I can get in touch with her and make sure that she gets that set up.
Ms. Thomas?
Thank you, Honor. Ms. Smith has joined us via Zoom, so she is aware of these proceedings, and I trust her to definitely get together with an FTM and look at parenting time and also to ensure that the children are getting sibling visits.
We reserve that also for placement if other names show up, Your Honor.
Of course, your client is always welcome to submit names. You should do that obviously to the department first so that they can be reviewed and researched using their resources.
Contact about a DNA test.
Any other questions?
No. Yeah, who should my client contact about getting this third DNA test?
Who's going to be facilitating that?
It'd be the foster care worker.
Okay, so that's Ms. Kristen Smith again. So she'll have a little homework on this one as well. An FCM, DNA testing. Any other issues? Thank you, everyone. We'll see you on this case on